Discovery is the opposite of all the great TV shows that you see. When you watch a legal drama, what you're watching for quite often is what's called trial by ambush. Those make for the best TV. It's when the guy pulls out the evidence that nobody has seen, or when the witness starts saying something that nobody's ever heard before, and it creates a lot of drama, and it creates great movies and great TV shows. In real life, though, that shouldn't happen. In real life, trial by ambush should never happen in a civil case. Why? Because of discovery. Discovery are rules that allow both sides to see what cards the other side has. Theoretically, by the time you get to court, by the time you get to trial, if you have conducted your discovery the way you want to, then you should know everything that the other side is going to say. And that's because you have all of these tools that can be used in discovery. There shouldn't be any secrets. There shouldn't be any surprise evidence. So, what is discovery? Well, the main forms of it are written in the state of Texas. Normally, they are written documents that are exchanged between the parties. So there are typically 4 written forms of discovery and 1 oral form of discovery that are used. Admit or deny that your girlfriend's name is Jane Doe, and on and on and on. Those things can be in request for admission. And request for admission can be very dangerous because if you ignore those, you can end up with something called a deemed admission. And a deemed admission means that the matter is admitted for all purposes and that the other side cannot bring forward evidence to contradict that. So if you mess around and you ignore request for admission when those are served on you, you can create some major, major problems for yourself. So you need to talk to your attorney about discovery because it's very critical and it's very dangerous to simply decide in your case that you just don't want to do any discovery because you want to save some money.